Well, hello and welcome back to my channel. My name is Joanne. I'm a law student from Australia. Oh, I got a new panel here. It's called Showtime. Ooh. I don't know what it does. I just clicked it. It says new. Okay. Want to thank you for that. Now, I want to have a look at what's been posted today from Katie Joy, and then I actually have downloaded all 90 odd documents from the court case, and we're going to go ahead and have a look, because I am certain that along the way she's made some assertions. Hello, Bella Marie, about things, and I want to make sure that what she has said is true and correct. So that's really what I want to do. So let's have a look at what she's posted on Instagram, first of all. Then we will start going through the documents. I actually started a spreadsheet and then it became too big. So I think we'll start from the bottom. We'll work at the claim, and then bearing in mind what's been said on Instagram today, we might have a better idea. I am certain, and if anyone's watching this and you have the videos of that, I'm certain that she has said along the way that she wasn't involved in this docuseries. I'm sure that it's on a video or it's on something or other, that it is written somewhere that she's either written it or something to say that she's not involved. So the first thing that she shared is this. So, you know, we've got to have our sister wives content. So she starts off with some sister wives stuff. So I guess Cody and Robin's argument that the kids aren't safe in Utah due to bullying doesn't make sense, given that Arizona wasn't safe for the kids either. Turns out being a public polygamist and forcing kids to be the face of an illegal life isn't good for their well-being. This clip from TLC Australia, where editors aren't trying to paint polygamy as benign and acceptable. International TLC editors paint the true story of the family that don't have agendas. So apparently this is from TLC Australia.
Isabel here in school, it's been the same. She's been bullied here too.
I understand that, but she's also one of the most popular people at school.
She'll disagree with you. Fine, you can talk to her. She'll disagree with you.
So I'm once again, I'm out of the loop on something going on with my kids that they're not communicating to me.
I thought just moving somewhere where it can be peaceful, to give the kids more of
parents that were there, that kind of thing is where I was.
When was the last time he lived in Utah?
So anyway, so that's what she said. So now she's watching international series of TLC. Now, she said here, Miranda Wilkin is posting videos dancing with her family. I'm sure isn't she Miranda Derrick, by the way? In my opinion, all of this is for show and to distract the truth, a strategy that was implemented by her higher-ups. They want to make everything look normal. The truth is, Kelly Dean and Melanie Wilkin will be all featured in a 3-part docuseries coming to Netflix on May 29, 2024. The Wilkins, along with former members and ex-dancers, will all come together to share their stories of abuse and trauma. There are families that will remain completely split apart. Miranda has a superficial relationship with her parents. It's probable that once the docuseries airs, that Robert Shin will fully cut Miranda off or ramp up her visits to try and disprove the claims they make. There is also a likelihood that Robert Shin will sue Netflix and the production companies as an attempt to reclaim the narrative, in my opinion. Well, I've actually said, as a segue, that they could depose the Netflix documentary to see what information was provided by Katie Joke, and we'll see that when we get there. It's a game for him, in my experience. I've dealt with him for 2 years in court. Everything I've experienced from him on court and online has been a game. He monitors my reporting. Court records indicate ex-dancers learned about his misdeeds through reporting and then came together to share their experiences. The overwhelming takeaway was that all of the ex-dancers that left had been misled, defrauded, and one of the females alleged sexual battery. Now, the question is, was it her reporting? Hello, Short Order Cook. If it was her reporting that alerted the dancers, then that strengthens 7M's claim. Robert has attempted to sue me for public statements other people have made and court allegations from public filings. There will be a huge push to make it seem like they are all free and capable to do as they wish. The propaganda will likely get worse leading up to the series. This should be ignored, discounted, and understood as a lie. The truth will be revealed, will be devastating and horrific. It's worse than anything I could have ever reported on my own. All of this will be revealed and more. So this is the synopsis, apparently, allegedly, of the Dancing for the Devil, the 7M TikTok cult. A group of prominent TikTok dancers are trapped in a cult masquerading as a management company called 7M. Among them is Amanda Wilkin, whose family is desperately trying to get their daughter out. As other dancers and former members escape and work to rebuild their lives, it isn't until they come together to try and put a stop to the cycle of their abuser that the real healing begins. That is the synopsis for the docuseries. So I personally don't think she should be doing she said the docuseries I've promised is announced on Netflix. I'm incredibly proud to announce that the docuseries Dancing with the Devil, she's written Dancing with the Devil, but it's Dancing for the Devil. The 7M TikTok cult is coming to Netflix May 29. Bringing this project to this point has taken more than 2 years of extensive work with producers, directors, and working with the former members of 7M and the Shekinah Church. Robert Shin filed a lawsuit against me and others involved in the production of this series, in my opinion, to attempt to stop the production and prevent people from coming forward. While the lawsuits are still pending, his threats and legal action did not stop the production. And this is what has me a little bit baffled, why Netflix would be willing to put themselves legally at risk. Because let's just say Robert Shin was to win, and they've used these people that have been found to be defamatory. Their sources are they've got bad sources. Anyway, Miranda Derrick remains inside the group. Public photos with Instagram with her family do not change the fact that she remains under the reins of Robert Shin and the team of mentors that control her career. Other dancers are also active in the group. I'm hoping this series will shine a light on the exploitation that occurs in Hollywood. Talented dancers and entertainers can be targets for people with nefarious intentions. I hope this series will give former members hurt by the group the validation that the trauma they experienced and the fraud that they endured is real. I hope this series will help reunite the families that remain split apart to this day because of this church/cult. I hope audiences can see the humanity of former members. Their voices will be finally on Netflix. So proud of being able to play a part in bringing this production as a consultant for the archives of records that had to be sifted through to accurately tell the story. This series is made in joint production with official WVW Entertainment and Dirty Robber, and special thanks to Jess, myself and I, and Tim Milgram for reaching out to me to help them bring this series to life. Also, a huge thank you to Wilma Vimara for believing in this project and showing incredible care and empathy and compassion to the families and former members. Now, that gives you the impression, does that give you the impression that she was a consultant on that? Does that give you an impression that she was a consultant with that? Hello, Harrison. I told you, by the way, I told you, Harrison, it would be a draw today. Because Miss Bowles, who has bought the receipts. Now, somebody, this is from Bowles. So Tim Milgram says it's about damn time, and she said, blood, sweat, and tears. Our dysfunctional family team made this happen. And then so you replied to their story. So I can't wait to watch. Is this the one that Katie Joy Paulson is working on? Someone said, kind of, not really. Her social media is in it, just like ours. Okay, I'm glad, because while I love your account, hers not so much. She posted she's a consultant, so I was wary. And someone said, no, that's not her title. So so Balls has got she's got all the receipts. Then someone says, are you in it? Can't wait. And she says, you'll have to wait and see. So I thought I thought that she had said in a court document that she wasn't in production, that she wasn't working on a production. So let's have a look. As I said, there's 90 odd documents here. So, but if Netflix, the thing, as I said, I think it's very, frivolous or very weird that they would actually want to do that with this all at play at the moment. Right, so let's start these downloads. So we want to look at what the accusations are. And I believe at one point in time they were asking for the names of people that she was working on. And as I said, if somebody has video of it where she says I haven't, or you've got the screenshots, then please do it. Now we're going back to the 5th of April 2022. Okay, so this was the original summons. It was amended. If you remember, it was actually amended to add Miranda and Derek. I mean Amanda and yeah. You know who I mean. The original one was just Robert Shin and 7M. So for their complaint against defendants Katie Mansky Paulson, aka Katie Joanne without a crystal ball, state and allege as follows: plaintiff 7F Films, a Californian corporation organized and operating pursuant to and in accordance with the state of California. Plaintiff Robert Shin is an individual resident of the state of California. Defendant Catherine Mansky Paulson, aka Katie Joy, is an adult member, a resident of Wright County, Minnesota. Defendant Without a Crystal Ball, LLC, WCB, is a Minnesota limited liability company organized and operated in accordance with the state laws of Minnesota with a principle of address of, so that's a holding company. Never seen that actually. The court has personal jurisdiction over defendants pursuant to the statute. The party, 7M, is a talent management company located in the state of California. Robert Shin is the CEO and the sole owner of 7M. Upon information and belief, Katie Joy is an internet personality and the owner of WCB. She, through WCB, monetizes her social media presence on YouTube, Twitter, Instagram, TikTok, and Facebook. Now, they have said, they're alleging that she runs and uses various social media usernames. So these are what they've attributed to her. Without a Crystal Ball Instagram. She's got 2 Instagrams, actually, because there's also Without a Crystal Ball 2. Culty Suts Instagram, Exposing 7M Instagram. I think they were deemed to be not her. Without a Crystal Ball YouTube, Without a Crystal Ball Facebook, well, she's changed that. WOACB official Twitter, Katie Joy WOACB Twitter, both I think have been deleted. And Without a Crystal Ball TikTok, and she's also got Katie Joy TikTok, by the way. Defendant Katie Joy holds herself out as an entertainment blogger. Defendant Katie Joy makes and produces and uploads drama and or tea videos and internet postings on her various social media channels. Defendant Katie Joy intentionally publishes false and defamatory material to denigrate others through sensationalism and fabrication of perceived drama for the sole purpose of enticing followers and viewers to help defendants. Monetize their various social media platforms accounts. Defendant Katie Joy intentionally engages in internet trolling under the belief, under both her name and various pseudonyms for the purposes of harassment and causing others consternation, grief, emotional distress, financial ruin, and otherwise cause damage to their reputation, well-being, and livelihood. Does this all start to sound familiar? This is starting to sound familiar. Defendant Katie Joy has a history of intentionally, maliciously, and recklessly publishing false and or misleading information about various people, entities, including plaintiffs, their clients, and associates. Now, we saw that when we looked at the Bates, Lydia Bates, yesterday, how she took something that was said and misconstrued it to get a storyline and the harm that caused. Defendant Katie Joy has at least 2 other lawsuits in this court for her malicious and defamatory statements made about others. Well, they were since settled from the time that, upon information and belief, Katie Joy, hang on, I missed one, didn't I? Yeah, Katie Joy holds herself out as an established YouTube personality and self-proclaimed internet troll with a professed obsession with the plaintiffs. I mean, you could argue that she just doesn't have a professed obsession over Robert Shin. She's got an obsession also over Cody Brown and the Duggars, or the Duggars. They said she posted under pseudonyms. They must know something, says Short Order. Well, I think they did. And I'm sure that I've seen a document which laid out the Netflix documentary information in it, and I'm sure that's an attachment from 7M. But anyway, upon information belief, Katie Joy has openly stated she will not stop going after the plaintiffs until no one works with them. Upon information and belief, Katie Joy has hundreds of thousands of followers on her various platforms. Upon information and belief, defendant Katie Joy is determined to continue exposing the plaintiffs, their associates, and any business who contracts with them until they are ruined. Upon information and belief, Katie Joy has been sharing private and confidential information about the plaintiffs and their associates to her social media pages with the intent of causing harm to plaintiffs. Upon information and belief, defendant Katie Joy's improper posts have been published to and are accessible to the general public, including her posts which contain false and disparaging information about the plaintiffs. Social media disparaging posts. And this is where they've listed them with the said links. Now, half of these have now been deleted, we know. Upon information and belief, defendant Katie Joy has made the following social media posts, which include false statements, malicious and misleading statements, defamatory statements. Now, this is where it's going to get interesting. She said that the dancers found out about the alleged cult via reporting. The question is it her reporting that did it? And who reported it first? So she's got here the 27th of the 2nd, 2022. Miranda Derrick was lured into Church of 7M. 7M is associated with the 7 mountains of influence. 7M believes they need to take over the spheres of the world for Christ to return to the earth. The M in 7M stands for mountains of influence, a Pentecostal belief to take over the world. Among others, please see post for specifics. Then on the same day, she said 7M is using religion to control time, money, resources of the dancers of the vulnerable. 28, the dancers managed by 7M Films don't pick their own music sets, clothes, or dancers. First of the 3rd, B Dash is a victim of the shins who was used to lure Miranda Derrick to 7M. Claims Miranda Derrick did not cut ties with her family before she was involved in 7M. 7M have been grooming Miranda Derrick. 7M made Miranda think her family is abusive. First of the 3rd, so the 1st of March, 7M is preying on vulnerable dancers, misstates promises by 7M to its clients. 7M controls its clients' lives. 7M blocks friends and family off its clients from reaching them. I mean, I could argue that if it's during work hours, yes, I worked in a government department where we had to actually lock our phones away in our lockers, and we weren't allowed to get them at the end of the day. If there was an emergency, there was a number that people had to call. You had to give that number out. I had to go through a switchboard, because when you were working for them, you were working for them. Anyway, I'm just saying. Then still on the 1st of March, 7M is committing crimes, including human trafficking. 7M stopped Miranda Derrick from being by herself. 7M clients are all part of the Shin's church. Robert Shin believes he gets prophecies from God. 7M cuts off its clients from speaking with people outside the organization. 7M is a cult. 7M is like Jim Jones's cult. 7M monitors its clients' when they are outside. 7M psychologically abuses its clients. 7M doesn't allow Miranda Derrick to drive. See post for specific allegations. Still on the 1st of March, 7M controls its clients' lives. It's abnormal for management teams to manage their clients' social media accounts. 7M controls everything its clients do. 7M is destroying their clients' lives. See post for specific allegations. On the 2nd of March, 7M and Robert are predatory. Robert Shin's church is tricking girls into following them. 7M and Robert Shin are shaming people into joining their church. Miranda and Derrick's marriage is fake, and they are lying about it. 7M doesn't promote its female clients. 7M is a cult. The Shins have been searching for people to prey on. 7M does not pay its dancers. Shirley Kim is always watching 7M's clients. 7M's clients are all falsely married to their spouses. Every person at 7M has changed their names and has different aliases. 7M's clients cannot do anything without consulting Daniel Joseph, including buying t-shirt and seeing friends and family. Robert Shin tells his clients that if they are not submitting to him, they are not submitting to God. If clients miss church, 7M takes away business opportunities from them. 7M's clients have meetings 4 times a week and are forced to work their way into church. If you are pulled out of church, you cannot do jobs and pay is taken away. Miranda Derrick missed a family funeral because 7M wouldn't pay her if she went. Robert Shin has access to all of the clients' bank accounts and brings it up in church. 7M doesn't pay their clients. Their clients don't know how much they are being paid. Robert Shin is telling clients they must submit to him. If they obey, they will be blessed by God. Dancers' lives are so tightly controlled that they can't do anything without speaking to Daniel first. Daniel Joseph controls the dancers' every move. 7M is controlling their clients' social media. Friends, family are being blocked from contacting 7M's clients. Management is isolating their clients and dictating every move. The dancers are worked constantly by their management. Robert Shin told its clients that God told them the magic required for TikTok algorithms. Okay. Robert Shin. I forgot some of these claims. They're pretty shocking, in my opinion. Robert Shin is telling his clients Christ wants them to be a certain way. 7M is a cult. Robert Shin is manipulative. 7M is underpaying the clients. 7M is exploiting their clients. Robert Shin is abusing clients of 7M. 7M is a cult, and the cult is that they are preying on black dancers, exploiting them, and convincing them that people don't like them for being black. On the 6th of the March, Shin's ruined relationship between the Derricks and Miranda Derrick's family. The 7th of the 3rd, 7M is a religious cult, tells people to not interact with 7M or their clients because they're a cult. Cult leaders commit crimes. 7M is exploiting their clients, telling people says see post for specific allegations, telling people the street address associated with Robert Shin. So she gave out his address, if you remember rightly, as well. The 8th of the 3rd, all of 7M and Robert Shin's clients are victims. Shin's are cult leaders. Robert Shin is a narcissistic person. Have we ticked off narcissistic so far on the bingo card tonight? Robert Shin asked his clients to live on his property. Robert Shin told somebody that God instructed him to teach young women about the birds and the bees. Robert Shin has conditioned people not to think. Robert Shin targets young women and introduces them into his cult. On the 8th of the 3rd, Katie Joy admits to contacting the LA Clippers to get them to cancel their contract with 7M and their clients. The 9th of March, Robert Shin's church is forcing the Derricks to live in the property owned by them. 7M is a cult engaging in human trafficking. Just because you say human trafficking does not make it true, though. The 9th of the March, 7M is a cult. Robert Shin essays women. And here's my other question. Why would you be posting this all up on social media and not have gone to the authorities with all the evidence, by the way? If you had proof that it was doing all of these things, why on earth are you posting on social media? Why haven't you just gone to why didn't she just call FBI Steve? On the 9th of the 3rd, Robert Shin is a cult leader. Robert Shin does not allow clients to own their own car. Robert Shin is spying on his clients. The 9th of the 3rd, 7M is a cult. Oh, yes. Robert Shin essays women. 9th of the 3rd, fact. WOACB located the home she and B- share. The home is also in Reno. Shirley Kim is a listing agent for the house. I shouldn't laugh, but the way that they've written that, WOACB located the home she and B- share. Is that what the problem is? She wants B- now. Then it's got posting private information about, on the 10th of March, posting private information about Robert Shin's address, claiming property is a cult compound. 7M is forcing clients to live in bad neighborhoods. Short order says no police or FBI Steve. She wants to be in charge of everything. Correct. 7M is forcing clients to live in bad neighborhoods. Robert Shin is stealing money from his clients. The 10th of 3rd, all dancers are grouped in homes within the same area, in homes owned by the church or managed by the church. With the current rental crisis at the moment, I'd just about live anywhere, to be honest with you, if it was a roof over my head and I wasn't out on the street, but that's just my opinion. 10th of the 3rd, Robert Shin directed Miranda Derrick to meet with her parents. 7M is a cult. Daniel Joseph of 7M controls all clients' decisions. I thought it was Robert Shin that controlled the decisions. 10th of March, the dancers are living under tight control and are not allowed to do anything without Daniel Joseph's permission. 10th of the 3rd, Katie Paulson has access and distributed to the public confidential court orders covered by a protective order. Same day, 7M is not trying to control the dancers. They want to control the government. Same day, 7M dancers exhibit numerous signs that they are being trafficked and lists the signs of trafficking. Robert Shin is using the dancers to further his real estate companies. In a sworn deposition, Robert Shin admitted he used millions of dollars in church donations to further his business and for his own fortune. Robert Shin propositions women for inappropriate contact. Robert Shin curses people who don't give him money. Robert Shin demands his clients submit to him. Robert Shin accesses his clients' bank accounts. Robert Shin forces his clients to divorce their spouses. Robert Shin takes money from his church to fund his lifestyle. Well, they can, as it's considered, isn't it a pay? Robert Shin does not pay his clients. Robert Shin won't let people use their own vehicle. Robert Shin forces people to put their kids in daycare. The 11th of March, Katie Paulson has accessed and distributed to the public confidential court documents covered by protective order. She admitted. Can you see how many posts she made? And she could have said it in about 10 posts altogether. She's on repeat for money. Correct, short order, court. Correct. Because she just keeps repeating the same vitriol all time. How many times has she said cult? She admitted to setting up a shell company, Mission 2020, in order to form other companies underneath the organization. He would start a business as DBA, but also short order cult on the segue. It would also help to, when you were talking about the harm element, and if it was found defamatory, compensation, because you could say she just repeated the same narrative over and over again. He would start a business as DBA and only incorporate after it became profitable. The businesses generated limited income, but rather used the funnel donations from the church to Robert Shin as payroll, bonuses, and interest. The fat money he received via these businesses were donations made by Lydia Chung and her trust. Shin took out loans from Shekinah Church for these businesses to pay himself via payroll, bonuses, and interest. He's using the church shell non-profit to defraud people and enrich himself by funneling donations to shell for-profit companies. On the 11th of March, she accessed and distributed to the public confidential court documents covered by protective order. The 11th of March claims improper management of church funds, holds dancers captive. The 13th of March, as of today, the church is conducting commercial business from the property out of ordinance and zoning. Robert Shin and his team are controlling every move these dancers make. They control their money, time, and are forcing them to live in a property they either own or manage. These dancers are being hurt by Robert Shin. These dancers are not paid by brands. They don't run their own social media and aren't making any of their own choices. Hello, Vedandra. They aren't allowed to answer questions, and everything must go through Hannah Shin. They're working long hours. The Shins are paying them a percentage after they are paid. Then the dancers are required to pay them rent, tithe the church, and donate to Robert Shin. Isn't that how it works in the entertainment industry, though? The people use a management company. They pay the management company. The management company takes out a percentage from that, and then the client, they get the rest of that. And then they would... And that says, Robert allegedly takes away privileges such as going to church, Bible studies, spending time with others in church, work opportunities, and collab. Well, he lives in a large home, drives a Bentley. He has all the dancers living in homes grouped together. The homes are through the church, and they pay rent to the church. 16th of the 3rd, we asked her, are the women at risk of sexual exploitation by Robert Shin? Lydia said, yes, they are at risk of sexual exploitation. Robert Shin forcing couples to divorce, cut off family, having them live in separate houses divided by sex. Relationships have been cut off by dancers because of Robert's coercion. Robert is taking away privileges and punishes dancers who do not submit. He demands full submission. They are not allowed to ask questions because their questions are evil. So the number of personal injury claims they have been filed against Shin or church members related to their cars, and you start to see threats are not just spiritual. Then add to that, Lydia Chung stated yesterday the women were at risk of sexual exploitation. 17th of the 3rd, MAC Cosmetics has confirmed multiple people that they are not partnered with 7M and have no plans to partner with them in the future. She alleged that after meeting Robert, he isolated her from her husband, convinced her that he was influenced by demons because her husband didn't support the kind of church, convinced her to divorce her husband, move into a home with other women from the church, then took full control of her life. Lydia was a recent immigrant from Korea when she first met Robert and his sister Catherine. She was also a trustee of a large fund in Korea, which held millions of dollars. She alleged that over several years, Robert Shin and Catherine Yi accessed her bank accounts. During this time, she alleged they forged signatories and transferred money out of her trust to the church. So we're still on the 17th of March. Former members alleged he's forced divorces, arranged marriages, and has had trysts with many women at church. One source alleges that one loyal woman was used as bait for real estate agents. They allege Robert would send women on dates with agents as bait to get listings for their company. So please continue to spread this out, that people need to stop collaborating with 7M or working with them. As long as they're working for Robert, they're being exploited. I've had multiple dancers reach out and say the male dancers are actively trying to get young females to join the group. We're not even halfway through yet. This is a 21-page document. This was the original claim. So we're starting right at the back. We could be here all night. 19th of the 3rd, 7M controls its client's bank account. 19th, Robert Shin barely works and lives off the work of his cult followers. 19th of March, her pastor and his wife, the woman of God, is also her manager. They dictate her own schedule. Same day, members must fully obey and submit to Robert and Hannah. We've got about 4 people here that they need to submit and obey to, so I'm confused. Robert and Hannah continue to force Miranda to respond to claims while having her accuse her family of doing what they are seemingly doing to her. Please remember there are dozens of Mirandas that have been victimized by the Shins. Now, don't forget, at this point in time, she's dealing with the Miranda's family. And you remember, the family has an agenda. And these aren't claims coming from Miranda. Members are to stop people called to stop people from becoming clients of 7M or working with them. Miranda Derrick has been kidnapped by 7M. Members are instructed to give 10% tithe, 10% gift of thanks to church, 10% love offering to Robert. Robert encourages that tithe should be more than 10% because the bigger the tithe, the bigger the blessing. Former members say they were given allowances by Robert and could not deviate from that allowance. The church members stopped having weddings because weddings are wasteful and money is not for weddings, but the gospel travel is not allowed because it's considered selfish and doing things for yourself. You cannot miss any church. Correct, Short Order Cook. She's brainwashing people. She's trying to gain support and persuade people through reposition of claims that her opinion is the opinion others must have, which is what a cult does, correct? Which is what a cult leader would do. On the 20th of March, Robert stole the money he used to buy his vehicle. 21st of March, pastors under undue influence to not only be the mentor and dictator of their lives, of the talent, but also managing and producing their careers is a massive conflict of interest. 7M is a church to run not-for-profit companies and control their members. 23rd of March, Robert Shin has waterboarded members of his church. Robert Shin refers to his followers as the mighty nation. He's taking scripture from Isaiah 60:22, which says the least of his will become 1,000, the smallest the mighty nation. At the right time, I, the Lord, will make it happen. His beliefs of separation of followers from family, isolating them through a belief that they are selected by God, is absolutely dangerous and can lead to drastic events like Waco and Jonestown. 23rd of March, calls of supporters to harass sponsor Forever 21. 30th of March, claims Miranda Derrick's post about Do Fasting app is Robert Shin forcing his clients not to eat. Multiple claims about Robert Shin's personal health and relationship with food. Robert Shin forces clients to be thin, claiming Robert Shin shamed his clients for being overweight. The 30th of March, again, reposting Miranda Derrick's paid sponsorship of Do Fasting app and claiming she's a victim of the cult and that 7M's clients are under mind control. 31st of March, ATT has cut ties with 7M following the allegations regarding 7M being a cult and the way they treat their dancers. 31st of 3rd Instagram story saying that Robert Shin targeted his clients and exploits them. 31st of March, Instagram story saying Robert Shin and B-Dash abandoned their children. Same day, Instagram story bragging about being the go-to for all information about cult leader Robert Shin. So continued disparagement. On the 10th of March, 2022, plaintiff sent a cease and desist letter to defendant instructing her to discontinue all and any claims about 7M, Robert Shin, Miranda Derrick, and any clients. So that was the 10th of March. So this is way back here. Is that why she ramped it up? She got a cease and desist on the 10th of March. Right? So this was the 10th of March. So then she went on about waterboarding, zoning, and then she went after the sponsors. got after their money. So she posted a whole lot here after she had the chief. So 23rd of March, she claimed that Robert Shin has waterboarded members of staff of his church. So after that, they'd been sent as cease and desist. In addition to removing all postings she's made about them, defendants did not respond to the cease and desist and accusing to post fake allegations about the plaintiffs to their various clients and associates daily, if not hourly. Plaintiffs reserve the right to amend these pleadings to include any and all posts made after the date of the last listed post and incorporate them. So then these were the count 1 defamation. Plaintiffs restate and incorporate by reference to paragraphs previously set forth. Katie Joy has communicated all of the posts outlined in this complaint to hundreds and thousands of people through her various social media. The false statements are categorically false. That Katie Joy knew false statements to be false when she made them, or at least acted with reckless disregard to the truth. I don't know that I could say that she knowingly knew the statements were false. I would say it was mainly reckless disregard for the truth. Katie Joy made this false statements with actual malice. That, again, can be hard to prove, but if this links around the time of the documentary, it could be you could use the documentary, the doco-series, if, as she said, she was a consultant and she was doing it, that could be used for malice, in my opinion, because there was a purpose for it. There was intent. She was trying to do it for motivation. I mean, the number, as Short Order said, she could have made the posts a lot shorter, had posted half of them, but she needed to hit home the same points. So she kept posting. Is that malicious? It could be. Katie Joy made false statements to further her own financial interests. She monetized the web traffic through these sensational and false claims. The false statements have caused and continue to cause the plaintiff significant reputational damage, reputational harm, mental distress, humiliation, hatred, contempt, and embarrassment. As a direct and proximate result of the conduct of defendants' false statements, plaintiffs have been shunned, avoided, and injured in their occupational business. By refusing to take down the defamatory posts and continuing to create new content with additional defamatory statements on multiple platforms, Katie Joy continues to make false and misleading and defamatory statements. As a result of the proximate result of defendants' false and defamatory statements, plaintiffs have suffered damages in the amount to be proven at trial, but reasonably believed to exceed $1 million. So the count 2 was defamation per se, which is very similar. So defamation per se, Katie Joy contacted individuals and organisations directly to disparage the plaintiffs. All the false statements made by Katie Joy, as outlined in Section C, are categorically false. Again, a disregard of the truth, malice, financial interest gain. The false statements accuse plaintiffs of committing crimes of moral turpitude. These allegations have harmed the plaintiffs in their trade and personal lives. So the trafficking, the waterboarding, that would, if people were taking those claims seriously, they're saying it is causing harm. And again, they're saying another $1 million. Tortious interference of contract. That's again where she's used the social media to get her followers to contact sponsors. And plaintiffs have had contract with several third parties for various commercial purposes. That she knew that these contracts between plaintiffs and third parties. She intentionally procured a breach of contract. Is the word consultant being used like the word journalist? I think so, Short Order. I think so. Again, another $1 million and commercial defamation. And it says hundreds, if not thousands, of posts, including original posts and comments on social media, have been made disparaging the plaintiffs and their business. And here, for example, defendants continue to boast about interfering with plaintiffs' contracts. And they've put in here the post from her Instagram where she said, I've spoken to multiple talent agencies and managers along with industry insiders who have applied pressure to the Clippers management to cut ties with 7M. Last week, an insider told me the Clippers abruptly cancelled Crucifield show for this week. The same thing happened this week. We are hearing extremely concerning information coming out about Robert Shin. We have heard that he and his team have been planning to build a sanctuary for artists to live, work, and pay them for everything. Multi-talent agents and managers have told me they are cutting ties with 7M. And it says, good news, they were cancelled for performance they were supposed to do that same night, as well as indefinitely. And the Clips agreed to launch an investigation into this group. So that's in the court documents. So that they knew the statements were untrue, that they knew that the third party would act on reliance. Again, financial harm, they're saying $1 million. So we're looking at about $4 million so far in compensation. And intentional infliction of emotional distress. This one is always really hard to do from my study of what we've learnt. And then negligence per se, and then that's another $1 million. Deceptive trade practices. They've disparaged goods and services of the business. And then intentional interference with prospective advantage. Doing stuff knowing that it was going to cause issues. And then for a preliminary injunction ordering defendants to make private all posts for the plaintiffs. For a preliminary injunction ordering defendants to discontinue in making any posts regarding the defendants. For permanent injunctive relief. For judgment in an amount exceeding $1 million to be proven to be a trial. And so that was it. That was the original. They were the original claims. Then we had an affidavit of service to say that it was served. I won't put that up because it's got an address in it. Then we've got some correspondence. So they had to amend it because remember they had to add the derricks in. So it's essentially the same, but now we have Miranda and James Derrick. And I won't really go through it again, other than let's just have a look. There'll be claims now regarding the derricks because remember, Miranda Derrick was accused of, the derricks were accused of several things. So this is 24 pages. This is actually 3 pages longer than the last one. And I think it's a bit longer because they added to it, if I remember rightly, to the claims. So let's go have a look. Now, oh yeah, so it says on the oh yes, knowing Miranda's parents are done so on the 2nd of the 4th, 2022, knowing that Miranda's parents are coming, 7M suddenly sends Miranda and James on a trip. In discovery, my legal team can subpoena all of their bank records, their taxes, the management contracts and pay stubs, and all their social media and email accounts assigned to any member. Not to mention, this would expose any and all activity that is not legal. Management has a right to take a commission. This is true. Members do not house their talent or have their talent attend their church. How much of the dancers tithing, donating to church and paying money to the man of God? Real management does not run smear campaigns against reporters. Why hasn't 7M gone after Rolling Stone, The Sun, Daily Mail, Beast, New York Post, Gawker, Daily Mail, TV, Insider, New York Magazine, Cosmopolitan, or any other of the former members or families have spoken out? When there is overwhelming evidence that there is something not right happening, it generally means something right is not happening. Human trafficking takes many forms, and this could or could not be. I'm not the police or the FBI, but I can share my opinion based on what I find. Freedom of religion is a constitutional right, and so is freedom of speech. This is not a dictatorship. This is not North Korea. This is the USA, where journalists have the freedom of the press. This is the first time she starts referring to herself as a journalist. Having accounts like this will not help any legal cases you seek to carry out. It will only prove my counterclaims. Maybe you should delete these pages since you wouldn't want them used against you in court. And on the same day, 7M controls clients' bank accounts. The 3rd of April. Now, you might understand why Miranda isn't talking to her parents. Hannah controls every move. WOACB is aware where the money came from, but we would like 7M to share where the money came from and which members' money was used to buy this Bentley. The 4th of April, dancers are still living in church community housing. They still share their lives, both in work and personally. There is absolutely no separation for talent from church and work. They live with their co-workers and church members. Keto Cycle terminated their relationship with Miranda after learning about her involvement with 7M. Former members agree that the only way to end the situation is to cut off the money and find a way for Robert Shin to be held criminally responsible. They assert that the money is made benefiting Robert and Shekinah. Report that Robert Shin Shekinah Church was illegally operating as a church without a proper zoning permit. 5th of April, getting sued is like a badge of honor at this point. 6th of April, I've never contacted Miranda or James. Alleges one of 7M's clients is using money from a fundraiser he runs to help Ukraine. Alleges a posted video from one of the 7M clients is a recruiting tool. And Robert Shin's next door neighbours are moving. I'm hearing that people have been driving by a lot, trying to spot Robert. I'm assuming this could be pretty disruptive to the neighbours. Real story is this. Focusing on the lawsuit distracts from the story. Stay true. So, and it talks about the cease and desist again, and the fact that they are still going, and then the rest of it's the same. Okay. So, so they did show the court that she was still going. So we've got that one. Then we have the fact the case has been filed. Oh, where are we? Just said there's 90 odd documents here. So, okay, that's there. The case of filing. So it was given, and there's representation. She did. They drove past because she gave the address. That is correct. That's what she did. Yep. All right. This was a notice of motion and motion. So this was her motion. Remember, her motion, her notice of motion and motion to dismiss. Remember, take note of the date of time to be determined. Defendants Katie Mansky Polston, and without a crystal ball will bring the following motion. A court for an order dismissing this action with prejudice due to failure to state a claim upon which relief can be granted. The motion for dismissal is made pursuant to Rule 12OE of the Minnesota Rules of Civil Procedure on the basis of other things. Plaintiffs cannot under any facts provide consistent with the theory of their case outlined in the complaint. Overcome the protections against libel suits afforded to journalists covering public figures. And 2, the fact that the most complained of behaviour simply consists of statements that are true or opinion, because plaintiffs' claims consist solely of causes of action that cannot be maintained. Defendants respectfully request that the court dismisses this proceeding with prejudice. So remember, she filed that. Then we've got her memorandum in support of her motion to dismiss. All right. And this is where she's talking about the fact that she's a journalist. So this was her memorandum in support, memorandum of law to support her motion to dismiss. Plaintiff 7M's, a talent aid management company representing influencers and other internet television personalities, and Robert Shin, the CEO and sole owner of 7M Films, Inc., and pastor of Shekinah Church, and Miranda and James Derrick. Collectively, the plaintiffs bring a suit before this court based on statements made by multiple media outlets about the alleged cult-like environment created by the plaintiffs and that environment's impact on the 7M clients. She never once said it was cult-like. Anyway, These reports have been published by media outlets such as Rolling Stone, the Daily Mail, the Daily Beast, as well as family members of 7M and a myriad of other YouTube outlets. The defendant, Catherine Mansky-Polson, is a journalist focusing on celebrity and entertainment news, among innumerable other items she has reported over the last year. Polson reported on first-hand accounts of personal experiences of dancers and influencers who formerly worked for the plaintiffs, based on information Polson has received directly and through other media outlets and court records. Due to the lack of substantiated claims provided by the plaintiffs in their complaint, I'll just stop here. I thought it was very clear. What they said, she said. That was anyway. Due to the total lack of substantiated statements provided by the plaintiffs in their complaint, the mere parroting of case law language without facts supporting its application, and the plaintiff's complaint's inability to overcome the protection against libel suits afforded to journalists covering public figures. And two, that the most complained of behaviour simply consists of statements that are true or opinion. Polson brings this motion to dismiss plaintiff's complaint. Defendants asserts that the complaint should be dismissed for failure to state a claim upon which relief can be granted pursuant to Minnesota R Civil Procedure 1200 and fully articulated here. Plaintiff Robertson is, by his own report, the CEO and sole owner of 7M Films Inc. He's also the pastor of Shekinah Church International, based in Santa Ana, California. All of these publicly known, objective, and easy verifiable facts about the plaintiff's public life, of which the court can take judicial note. Defendant Catherine Mansky-Polson is an individual resident of the state of Minnesota and a nationally known entertainment and celebrity journalist. She's regularly cited and reported on in national publications, such as People Magazine, In Touch Weekly, The Today Show, US Weekly, and more. She has a YouTube channel with 186,000 subscribers. This was in 2022, which has a forum in which she broadcasts most of her reporting. Her videos have generated nearly 88 million views. See the website. These are publicly known, objective, and readily verifiable facts of which the court can take judicial note. In her career as an entertainment and celebrity journalist, Polson has covered the allegations regarding plaintiffs, their business practices, the treatment of their managed talent, as have many other media sources that cover similar material. A cursory review of state and federal dockets for the states and districts in which other media sources, such as the Rolling Stones, the Daily Mail, and the Daily Beast, are headquartered, indicate that despite similar coverage to that of Polson, none of them have been sued by the plaintiffs for defamation, libel, or any similar torts. So here's their argument. Standard of review pleadings that fail to state a claim on which relief can be granted must be dismissed. A motion to dismiss tests the legal sufficiency of a complaint. There's the case law of Witzman versus Lemon. Sorry. When determining the motion to dismiss, court takes the facts alleged in the complaint as true. Yes. On the motion to dismiss for failure to state a claim, the district court may consider only the complaint and the documents referred to in the complaint. So when they're reading the allegations, they have to assume that it's true. Remember, Katie has to defend or show that what she said was either her opinion or was fact, and show how she's come to those conclusions. A complainant states that a claim for relief, if it is fairly gives notice of the claim, is sufficient to permit the application of the doctrine of res judicata. However, the court is not bound by legal conclusions stated in the complaint when determining whether the complaint survives a motion to dismiss for failure to state a claim. Furthermore, in a complaint, a plaintiff must provide more than labels and conclusion. A claim is sufficient against a motion to dismiss for failure to state a claim if it is possible on any evidence which might be produced consistent with the pleader's theory to grant the relief demanded. Walsh does not require the court to develop additional theories of the case that may constitute a basis for relief outside the plaintiff's theory of the case solely expressed in the complaint. Finally, important in this matter, due to its involvement of a public figure and public records. On a motion to dismiss, the court may consider, in addition to the pleadings, material embraced by the pleadings and materials that are part of public record. Even when addressing the motion to dismiss, the court may take judicial notice of filings, a public record, and the fact, but not the veracity of parties' assertions. So on the facts alleged, plaintiff cannot meet the doubly heightened standard of defamation against members of the media by public figures. So this is really what she was trying to get dismissed on. She's saying, I'm a journalist, they're public figures. On a plain reading of the typical defamation standard applicable to interactions between two ordinary private individuals, plaintiff's complaint may hold water, if not for the fact that the alleged defamatory statements by the defendant are true, as stated in section B below. However, this case is not one of simple disagreement between two such private individuals. Rather, the parties consist on one hand of a well-connected talent management company whose role is in representing influencers and other media personalities is to specifically be in the public spotlight, and its CEO, who is not only a public figure for his not-for-profit business dealings, but is also a pastor of an international church. And on the other hand, a nationally prominent entertainment journalist to whom protections are afforded, the press and the media apply. In this case, the plaintiff cannot merely rely on either the common law formulations of defamation or the Minnesota Supreme Court's holdings in the case, because Statute does not address the application of its principles to either members of the media or to public figures. Under Sturmberg's, the elements of standard defamation of action require that the statement was false, that it was communicated to someone other than the plaintiff, and that it tended harm the plaintiff's reputation and lower him in the estimation of the committee. That is basically that is actually the standard for defamation. So when you look at statements, it's usually, was the statement false? I was going to go all night, Harrison. Was the statement false? Was it communicated to more than one other person other than the plaintiff? And did it intend to do harm to that person? And if you can meet those three, generally that's defamation. Well, Sturmberg's is useful in providing guidance on the question of whether a defendant made statements with actual malice. We need to look at other sources for application of defamation standards in this matter, because the sources of law applicable to Minnesota provide an increased burden of proof for a plaintiff alleging defamation by a journalist. And if the plaintiff is a public figure, plaintiff's complaint cannot meet those standards and must be dismissed. Not at the moment, Harrison. All right. So they're saying because she's a journalist and because he's a public figure, there's a heightened burden of proof that needs to go up. And we know for a fact that in the last rulings, the judge had said that her journalism status had not been, a decision had not been made whether she was a journalist on one way or the other. So it says to be actionable, alleged defamatory statements involving a public figure must be false and may be made with actual malice, which cannot be shown in this case. So remember, these motions got dismissed as well, I think, if I remember rightly. A long history of United States Supreme Court cases provides protections for journalists making negative statements about an individual. In its landmark case, New York versus Sullivan, the United States Supreme Court adopted a new set of constitutional protections for publishers of information relevant to public discourse. Liable can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. The general proposition that freedom of expression upon public questions is secured by the First Amendment and has long been settled in our decisions. Correct. I mean, that's the way she, and the way that she wrote it. I mean, if you look at what I've written on my community posts, I've actually made them questions. I've posed them as questions, and I've said, what's your thoughts on this? So it's a matter of, I don't know, Harrison. It's a matter of, because she made them as statements of facts, where when I was talking about these things today, I didn't make them as statements of facts. I actually asked questions, and that's if she had said, you know, it's important, you know. I don't know. She could have done it a lot better. Authoritative interpretations of the First Amendment guarantees have consistently refused to recognize an exception for any test of truth, whether administered by judges, juries, or administrative officials, especially one that puts a burden of proving truth on the speaker. The constitutional protection does not turn up the truth, popularity, or social utility of the ideas and beliefs which are offered. Minnesota adopted the holdings and consequences of New York Times in Rose versus Koch, agreeing that state laws are liable that fail to provide safeguards for freedom of speech of the press guaranteed by the First Amendment to the United States Constitution and made applicable by the states by the 14th Amendment are constitutionally deficient. The Minnesota Supreme Court went on to adopt a number of holdings produced by the New York Times. So it says, first, public officials and other public figures are subject to vigorous attack, including under certain circumstances, defamatory and untruthful attack. Second, the privilege of defamatory attack is applicable to public figures, even though such figures are not public officials. Third, the meaning of actual malice stated in the New York Times, although not fully articulated in the subsequent decisions of the United States Supreme Court, has been given definition, at least in terms of what it is not. What the New York Times rule ultimately protects is defamatory falsehood. No matter how gross the untruth, the New York Times rule deprives a defamed public figure of any hope for legal redress without proof that the lie was a knowing one or uttered in reckless disregard for the truth. And it says, after the New York Times, the additional lines of cases include Rosenblatt and Bayer, and about expanding the application of public official to elected official to non-elected official. In Times versus Hill, it talked about concept of non-governmental issues, and Curtis and Co., which expanded it to application of public official to public figures regardless of affiliation with public or private entities or issues. So based on that argument, though, you would say she was a public figure. Just saying. Okay. In addition to Minnesota's adoption of the New York Times line of cases, reporting statements made by law enforcement is specifically protected for journalists in Minnesota by the fair report privilege. I don't think she used any police reports, though, did she? The fair report privilege applies to fair and accurate reports of statements by law enforcement, and the fair report privilege protected fair and accurate news report about a press conference and news release. Summarizing the Minnesota courts. We haven't even got to the good stuff yet. We're just, we've only just started. As I said, we've probably got a long night ahead of us. It's going to be a long one, I think. Because I'm going to stay up until we've gone through all of these documents and see whether we can link back to her statements today. So, summarizing the Minnesota Supreme Court analysis in Marino and Crookston Times Printing Co., the Larson Court highlighted the Marano Court's reliance on the restatement, Second of Torts, 1976, at section 611, which states the publication of defamatory matter concerning another in a report of an official action or proceeding or of a meeting open to the public that deals with a matter of public concern is privileged against claims of defamation if the report is accurate and complete or fair abridgment of the occurrence reported. Similarly, the Minnesota Court of Appeals stated in Jadwin versus Minneapolis Star and Tribune that newspapers have a qualified privilege when making fair and accurate report of public records. Many of Paulson's recitations of the complained of material is drawn from public court documents. Well, actually, that's disputed because 7M said that they were privileged, they were sealed documents. But anyway, so her argument was many of Paulson's recitations of the complained of material is drawn from public court documents, regardless of the light in which those statements paint plaintiffs and regardless whether the plaintiffs agree with those statements. They are privileged against claims of defamation and thereby improper basis for the causes of action listed in the plaintiff's amended complaint. Plaintiffs Robert Shin and Miranda Derrick are public figures subjecting defamation claims to a different standard. As to whether public figures may take action against journalists or anyone for that matter, reporting or publishing on information about their investigation into public figures' activity, the Constitution delimits the state's power to award damages for liable in actions brought by public officials against critics of their official conduct. As noted in rows above, public figures are subject to vigorous attacks. They must show actual malice, which is not what it sounds like. Rather, for a public figure to recover on a claim of defamation, he carries the burden of proving that the alleged lie was a knowing one or uttered in reckless disregard of the truth. I've taken a segue here for a moment. I believe it's more likely to be a reckless disregard for truth. Look at all the people that she's got excited over the sister wife stuff. You know. So let's get back to the document. In the case of Gertz versus Robert Welch, United States Supreme Court articulated 3 classes of people for the purposes of analysing defamation libel claims. In full, hypothetically, it may be possible for someone to become a public figure through no purposeful action of his own, but the instances of truly involuntary public figures must be exceedingly rare. For the most part, those who obtain this status have assumed roles of special prominence in the affairs of society. Some occupy positions of such persuasive power and influence, and they are deemed public figures for all purposes. More commonly, those classified as public figures have thrust themselves to be forefront of particular public controversies in order to influence the resolution of the issues involved. In either event, they invite attention and comment. There was also another breakdown. The first group includes the rare involuntary public figure. The next category is essentially contained celebrities and prominent social figures who are deemed public figures for all purposes. And the final group consists of limited purpose public figures who obtain their position by thrusting themselves into the vortex of a public controversy to influence its outcome. Regardless of whether we use the Gertz or the Jadwin formulations to guide us in this case, currently before the court, the outcome is the same. Plaintiffs Shin and Miranda Derrick are no mere private individuals. Plaintiff Shin is the CEO and sole owner of 7M Films, which represents and promotes influencers, additionally producing and posting their own dance content. Plaintiff Shin is also a pastor of a Shekinah church, and a church located in Santa Ana, California. Just another segue. Just because he's a CEO, though, doesn't make him a public figure. There's lots of CEOs that you don't ever see behind a company. That's what they have employees for, right? Just a point. And being a pastor of the church doesn't make you a public figure either. Plaintiff Miranda Derrick has intentionally made herself a popular influencer in social media circles and spoken about the circumstances of her situation with Shin, 7M, Shekinah Church, publicly and voluntarily. Plaintiffs in this case before the court are without doubt public figures. They've thrust themselves into the media spotlight through their production and talent management company as the pastor of Shekinah Church, and their huge social presence, Miranda Derrick, whose Instagram account today includes 559 posts and boasts 1.3 million followers. Whether it is for all purposes only or only with respect to the issues they raise as basis for their defamation claims, plaintiffs are public figures, and as public figures, plaintiffs cannot rely solely on the standard articulation of defamation provided by Stempegs. Rather, plaintiffs must meet a higher burden of proof and prove the statement was made with actual malice. That is, with the knowledge that it was false or with reckless disregard for whether it was not false or not. To recover against the defendant, a public figure must meet an elevated burden of proof and show not only the statements were false, but also that the defendant acted with actual malice. So they've done that again. Then they've gone here in regarding similar intentional torts of damaging a person. They've got that there, nor the fact that the defamed public defendant published defamatory material in order to increase its profits is suffice to prove malice. Although the concept of reckless disregard cannot be fully encompassed in one infallible definition, we have made clear that the defendant must have made the false publication with a high degree of awareness of possible probable falsity, or that it must have entertained serious doubts as to the truth of his publication. Surely some of those claims, though, were so wild that you would have had doubts about them. Plaintiffs have failed to include a single piece of evidence capable of proving that Paulson's allegedly defamatory statements were known lies, or that they were uttered in reckless disregard of the truth. Plaintiff has provided the precise opposite of that necessary proof, acknowledging Paulson reported on information from court documents. Table of claims including many that Paulson simply reported on court documents. Yes, but they were under seal and protected. Furthermore, plaintiff acknowledges that other businesses were convinced sufficiently of the veracity of Paulson's sources and information, and they launched their own investigations into plaintiffs and cut business ties with the plaintiffs. The remainder of the plaintiff's amended complaint restates ad nauseum asserted legal conclusions, using the alleged defamatory statements as the basis to allege a myriad of other claims without providing a single actionable allegation under the standards of the New York Times and Minnesota's adoption of therefore in Rose. Plaintiff relies on a series of assertions to provide no proof and no basis for meeting their burden to show actual malice as defined in case law. For instance, plaintiffs rely on speculation on the basis for their allegations in the following paragraphs: on information and belief without evidence, on information belief. So they're saying where they've said on information and belief, and they say, well, there's no evidence for that. Claiming to know Paulson's mind without any evidence to support it. So they've put 21, 22, 23, 24, 25. Similarly, plaintiff complains repeatedly of Paulson's reporting on filed court documents without any explanation or allegation supporting proposition that reporting on a court document is the basis for defamation sufficient to overcome the burden required by public figures making defamation claims or for fair reporting privilege. Again, simply reporting on information from a court document, whether confidential or not, so whether it's confidential or sealed, they're saying it doesn't matter, is not sufficient to undergird a cause of action for defamation against a public figure, particularly in light of the fair reporting privilege. I don't know many reporters that would actually breach that rule myself, but anyway. They often will actually go to court and ask the court to unseal the documents. I mean, that's how Bruce Lerman ended up being named in the Toowoomba case, because the media said, hang on a minute, you've sealed this, we want to talk about this, we want them unsealed. Anyway. And plaintiffs to provide no basis for allegations that the court documents accessed by Paulson were confidential. I'm sure she did too. I think someone called her out for it and she said, oh no, anyway. Nor how Paulson even obtained copies of documents covered by a protective order, which only could have feasibly occurred if one of the parties to an action broke privilege, violated an alleged protective order, an allegation which strains cruelty. Finally, Paulson's own statements about reports she received directly from former members of 7M and the family and friends of members of 7M cannot be actionable under the New York Times line of cases because they have an even stronger defense. They are true. They are true. True statements, however disparaging, are not actionable. Each statement in paragraph 25 of plaintiff's amended complaint either is a true statement, B, is taken from a public document, or C, Paulson's opinion. For this reason, it cannot support a defamation claim under any theory of defamation available in Minnesota or on the basis of any related claim. Even on the most favourable reading of the amended complaints allegation, plaintiffs provide no basis for one, overcoming constitutional protections for the press, meeting their burden of proof, that actual malice of public figures. There we go. They said, because they are true. They're either from court documents or her opinion. But they don't ever put that in their defense, by the way. And then tortious interference, that the Clippers contract was breached, nor is it likely it was breached, given the common escape positions. Yeah, So that was the reason why they did. That was that one. I'm sorry, I'm sort of skipping through them because I'm very much aware. So this was the proposed order that they were hoping to be signed, and that was supposed to put the end of it all. Remember that? Then we had a notice of remote hearing, proposed document, notice of remote hearing with instructions. Then we had their opposition, because they opposed it, remember? So they got to oppose it. So this was the memorandum is submitted in response to the defendant's motion to dismiss. Plaintiffs contend that the motion to dismiss is improper and without merit. All right. Dismissal is proper when a plaintiff's complaint fails to state a claim for which relief can be granted. In determining the motion, so that's essentially the same. They look at that. A claim is sufficient against a motion to dismiss for a failure to state a claim if it is possible on any evidence which might be produced consistent with the pleader's theory to get the relief demanded. Okay, so they talked about addresses only 2 of the 9 claims of, so they put in, so they say they argued 9 causes of action and they only talked about 2 in their defense. So however, in their memorandum of law in support of defendants' motion to dismiss, defendants have attempted to dismiss the claims for count 1, defamation count 3, tortious interference of contract. Plaintiffs have set forth 12 pages of factual allegations in their complaint which support these claims. Examples of these factual allegations are that the plaintiffs committed various crimes, including human trafficking, kidnapping, waterboarding, and that the plaintiffs are leaders and members of a cult. The relief requested by plaintiffs is consistent with the legal theories pled, as well as factual background of this case, that the plaintiffs have properly pled numerous claims for which Minnesota courts may grant relief, included significant factual allegations to support these claims, and asked for the relief commonly granted by Minnesota courts. Defendants' motion to dismiss should be denied. So then we've got their arguments as to why it should so it says plaintiffs have set forth a claim for common law defamation count 1 of their complaint. Minnesota is a notice pleading state and does not require absolute specificity in pleading, but rather requires only information sufficiently to fairly notify the opposing party of the claim against it. Under Minnesota law, the pleading of broad general statements that may be conclusory is permitted. A pleading will only be dismissed if it appears to a certainty that no facts which could be introduced consistent with the pleading exist which would support the granting of relief demanded. In the first paragraph there, they've just absolutely wiped the floor with them, in my opinion, because they were saying that they had no pleadings, and she's come back and said, well, actually, the law states that you don't actually have to have pleadings. The elements, so then we've got common law defamation there. Plaintiffs have also pled facts which support each element of their claim. If each of the factual allegations in the plaintiff's complaint are construed as true for the purposes of this motion, plaintiff's claim for defamation will succeed, as the plaintiffs have pled sufficient facts and allegations to support the claim for defamation. Defendants in their memorandum of law allege plaintiffs cannot meet the heightened standard for defamation regarding the action against members of the media by public figures. This 2-part argument is wholly unsupported by any law and in fact contrary to well-established federal and state law. Plaintiffs expressly object to defendants' attempts to judicially notice the court and opposing counsel that 1, defendants are members of the media, and 2, plaintiffs are public figures. Defendants attempt to argue the merits of this case in their motion to dismiss is further proof that their motion is improper. So I'll repeat that again. They said that they object to the defendants pulling out the card that they're media. Okay. As plaintiffs' argument regarding their alleged status as members of the media, there is no blanket exception which precludes a member of the media from being named as a defendant in an action for defamation. There are instances where qualified privilege may be taken into account as an affirmative defense to a legitimate defamation action. However, a motion to dismiss is not the proper avenue to assert these defenses. Yes, she should have actually pled a qualified privilege defense. Although plaintiffs assert defendants are not members of the media, defendants have the opportunity to present any affirmative defenses, including any potential media defenses, in their answer. They didn't do it. Second, plaintiffs are not public figures, limited public figures or public officials, which would subject them to the additional element of actual malice necessary to prevail on an action for defamation. Such a determination is an issue of law for this court to consider after proper briefing. Without conceding the issue of plaintiffs' status as public figures, plaintiffs did plead actual malice in their claim for defamation. So they keep talking about that, and they said that they've played actual malice. A final determination of actual malice is not required at this stage. And then we've got tortious. So they've now gone to tortious interference of contract. Okay, I'll let you read that. Okay. Then it just says, conclusion, defendant's perversion of Minnesota law and inability to apply the facts to allegations does not negate the validity of the plaintiff's claims. Plaintiffs have pled specific facts and allegations which support each and one of the 9 claims in this lawsuit. As such, plaintiffs must be allowed to move forward on the merits of their lawsuit. For this foregoing reason, plaintiffs respectfully request the court to deny. Okay, so we got to there. Then we had a proposed order. Then we got another memorandum. All right, so this was a reply. This was a reply memorandum. So remember, they brought the action. Whoever brings the action gets a right of reply. So it says plaintiff's claims all revolve around the alleged statements made by defendant Paulson and claims alleged to have flowed from those statements. Because defendant's statements do not meet the legal standard for defamation, both plaintiff's claims regarding the alleged defamation itself and claims stemming from the alleged defamation should be dismissed. Case laws, the rules of evidence, and the full record currently before the courts support defendant's position that plaintiffs should be dismissed with prejudice. So then they're repeating the fact that the plaintiffs are public figures is indisputable fact, which the court could very appropriately take judicial notice. Again, that's repeating that case law. Plaintiffs have failed to prove any facts to support their claims that actual malice exists based on the public figure exception. Plaintiffs have made no argument the defendant made the alleged statements in reckless disregard of truth. This position is further bolstered by the fact that defendants are not alone in this line of reporting. As previously noted, many news outlets have reported on the same or similar allegations. Regarding plaintiffs, their business practices and treatments of their managed talent since filing the defendant's motion to dismiss. Even more reports have emerged with HBO, Chrissy Teigen, announcing they are creating a docu-series based on the plaintiffs and the same allegations with wide coverage of the plaintiffs. So here we've got mention of a docu-series and stemming from the alleged, so all alleged defamation as the basis for the claim. Most of the claims stem from the alleged defamation. Plaintiff's claim of intentional infliction of emotional distress isn't even based on defendant's behaviour, but rather on the behaviour of others, is what they're saying. And again, they bring in about Rolling Stone and everything. It says, due to foregoing reasons, defendants request that. So this is a Christian Hendrick doing this stuff. Then we've got a scheduling order. We had a scheduling order filed where this was pleadings by the 5th of August, alternate dispute resolution, just November, joint statement of the case by February, motions, pre-trial conference, and it was all supposed to be done and dusted it was supposed to go to trial on the 18th of April 2023, but it didn't. All right. So then we got an order. Oh yes, that's right. Then we had the scheduling order debacle. Because the motion to dismiss was not due back to the end of August and they hadn't served their answer, if you remember. We had this debacle. And then we had this one. And this was from Graham M. Martin. The plaintiffs initiated this action by serving a summons and complaint on my client. They amended the complaint. They responded. This was where they filed out of time, where they didn't realize that they only had 30 days. That motion has yet to be heard by the court. If the court denies our motion, our clients will find will file an answer. Can you remember that? So, and then they've said, well, they've not done anything. Each and every one of those discovery methods has been made available. If the plaintiffs need additional time, and then he went, he tried to be, so that they had 21 days to file, and they didn't. They messed up. Then we got a notice of judicial determination. Absent stipulation, any request to extend deadlines to the court must be done via motion. So that was that one. And then there was, and then she put that on Amber's one as well. You want to do it, you got to file a notice. Then we got the order denying the motion. The defendant's motion for counts 1 to 10 is denied. The attached memorandum, she denied it. Okay, the order was denied, and here was why. So the amended complaint was 9 causes of action. I'm just having a look. Then it's all the legal stuff. I want to get to the good stuff. Before the court turns on whether allegations in the amended complaint are taken alone and assumed to be true, form a legally cognizable claim for relief. Or defendants provide an admirable summary of Minnesota and United States law concerning defamation involving public figures, and argues that plaintiffs will be unable to prove that defamation defendants acted with actual malice. Those issues are not properly before the court in the present procedural posture. Assuming arguendo that all plaintiffs are public figures and thus subject to actual malice standards, plaintiff's amended complaint pleads actual malice. Whether they are able to prove that defendants acted with actual malice is another matter. Oops, I need to show you this. So Minnesota is a notice pleading state. And it says, in their complaint, plaintiffs set out in great detail the statements with dates, web links, and either quotes from defendants or apparently summaries of posts contained in the table, stretching from pages 4 to 12. In at least 2 of the entries in that table, dated the 1st of April and the 2nd of April, located on pages 10 and 11, plaintiffs appear to quote verbatim defendants making public statements on social media, accusing plaintiffs of engaging in human trafficking, exercising its gatekeeper function. The court finds at least one of those statements convey a meaning which is reasonably defamatory. Accordingly, the plaintiffs have properly alleged facts, if proven at trial, would entitle them to relief. Did you remember that? Did you all forget that she said, that this judge said that at least one of those statements could be deemed to be defamatory. Is this also the one that she said that it was plausible? So she lost both of her motions there. Okay. So yeah, so that was the motion. That was her response to the motion to dismiss. All right. So that was done. All right. So now we get to this was a notion. Then we get a motion of motion for temporary injunctive relief, protective discovery order, and amended scheduling order. Okay, they wanted stuff to be done under seal because of these issues. So this is 3 pages, memorandum of support of amended scheduling order. So this just outlines the fact of reasons why, because it talks about only scheduling 10 days of this notice, that they attempted to contact the court. The court didn't return any calls, that there's been no answer. Remember, there was no answer. Defendants are not yet served an answer. And so they wanted the changes to be defendants' answer due 9th of September, discovery completion by 30th of December. So then we got another motion, another one. This was for a temporary injunction. I'm sorry if I'm going through these. I actually have a Google Doc that I've got all the documents in, and I'll post the Google Doc so you can actually look at them again. So this was an order for protective discovery, and it was also for an order of injunctive relief. And oh no, that was the one we looked at, wasn't it? Right. So they wanted an injunction of all postings. So the plaintiffs respectfully request that the court grant their motion for temporary injunction enjoining the defendants from posting any online content from the plaintiff. In the alternative, if the court decides that a temporary injunction of all postings is inappropriate, they respect that the court requires the defendants include with every post she makes about the plaintiff or their associates that in the picture of blocks of text relating to plaintiff and associates that she's currently engaged with litigation. And then it talks about the case, persistent and malicious harassment of the plaintiffs through social media platforms, YouTube, TikTok, and Instagram, that they keep publishing countless amounts of false and defamatory statements, including the accusation of human trafficking, kidnapping, waterboarding. They've demonstrated dedication to adhering to the plaintiff's contracts. A temporary injunction is appropriate. So then they've gone through the parties again. Again, more of the social media attacks again that they've included, and again, referring to the affidavits, the lawsuit. Defendants have made numerous statements about this lawsuit, including that they will continue to report on this lawsuit in plaintiffs. After a brief pause, defendants have restarted their harassment of the plaintiffs. Despite ongoing litigation, defendants have stated she's back reporting on the 7M story and won't stop, etc. And then the legal argument, why they want the injunction, and that it's going to do irreparable damage. Okay, it talks about the LA Clippers, the Dalberg factors of analysis. Yeah, so it talks about would suffer irreparable harm if the defendant continues their false and defamatory social media campaign. The severity of the defendant's actions, such as claim of human trafficking, waterboarding, operating a cult, can cause irreparable damage. Plaintiff can demonstrate a likelihood of success. And they're talking about here in this matter, defendants have published countless of posts regarding the 7M and its associates through various social media platforms, and then they've reiterated the waterboarding, the human trafficking. That is their strongest. That's their strongest claim, always has been. And then talks about the policy position. The plaintiff's motion for temporary injunction is not granted. Plaintiff 7M will suffer irreparable harm if there's no adequate remedy, is what Amber had said. Okay, and then we have no, that's the one we've just done. Then we've got the affidavit of attorney. Now, bearing in mind, not all the documents are here because some are put away. Now, I think these are the interesting ones because this is where we've got all the exhibits. Okay, so this was the first lot. This is the amended complaint. So we've got the amended complaint here. Let me go to the next one. So remember, that's all. She's reminding the court all of that. So, and then we've got the LA Clippers one, if you remember rightly. She's got that in there. The next one, that's the, and then we've got this post. All the evidence is here. Okay. Then this one. And then someone called her out and said it's a false narrative. Okay, this is my opinion. I'm all ears. Okay. And then there's this one. Other accounts have enjoyed ridiculing, mocking, and bullying dancers in the story. I will not and will not be affiliated with any of these accounts. My team is behind the scenes. We care about this story. On IG, I'm solo, period. So here she's talking about a team. A team. My team, people. A judicial determination lawsuit filed against has not gone in their favour, according to a scheduling order filed in court on July 18. Or discovery request was supposed to be. So she was, she's talking about the judge determined there were no extensions for delay can be granted without a motion for delay. No such motion was ever filed. WIOC disputed their request for a delay because the delay was requested after the deadline. Since April 2022, the plaintiffs have made no attempt to discovery. The judge is yet to rule on our motion to dismiss. And we know what happened there, don't we? Most interestingly, many people have reached out to WIOB to share that several dancers no longer have 7M listed as their management company. Could some of the dancers be leaving the group? And she said Shin and 7M missed the discovery deadline. Then there's this one. And this one. Is this bringing you back to memories now? This one, confidential communication. I called twice, leave 2 messages for the court. The scheduling order. Then we've got case law here. She's put in, which is great. Case law's good. Then we've got Josh Duggar watched the adult content Day of the Raid, researchers related to it. And here she's showing that she's showing court filings. He was homeschooled, so she's saying she has no problem taking court documents. And the lawsuit, and this is Todd Chrisley's one she shared. And game on, counterclaims coming your way. That was her response to getting sued by the Shins, Robert Shin. So they've shown all of that. And then we did the protective order. Then they did a motion for protective order. They filed a whole pile of motions at once because they didn't want the information getting out. And then we have oh yeah, that is that one, isn't it? Yeah. Oh no, there's more here. But is this it? Yeah, this is a big one because this is 71 pages long. So let me just pick up where we got to before, because this one's a bigger one. Here we go. They've even been to Reddit. They even used Reddit in there. See, no time or date shown, hun. You spoke to the Clippers, right? I did. Who did you talk to? The director's a friend of mine. So they even shared Reddit. Yep. And yeah, so yeah, the game on. And then another document there. So we've got that one. Then we've got affidavit of plaintiff. So then we've got affidavit from Katie Joy. Oh, no. Sorry, this is James Derrick's affidavit. James Derrick's affidavit, and this is where he's talking about all his costs. Okay, what are his earnings? And then we've got affidavit of Miranda Derrick. No, Robert Shin. Sorry, Robert Shin. And talking about the financial losses, how much is lost, and the fact that they lost some sponsorship, all the sponsorship. Okay, so they've got that lawsuit. Yeah, that. Hi Miranda, could you remove our story, please? We received a lot of criticism. So stuff that they had, they lost all of that stuff. And then this stuff, Spank supports women's, not cult. And then about contacting the Clippers. So we've got that, and then I think there's oh, that's James Derrick. And here's Miranda Derrick's one. And she says here, I've never lied about the existence of my marriage. And then talking about, so again, her payments, and her loss of contract that she lost. So then we got notice of motive hearing, another motion of motion. This was amendment of notice and a default judgment, because remember they had missed their answer. So we're into October now. Then we got the answer. And this is where they admit the paragraphs, jurisdiction, the parties, social media presence. It says defendants are without special to deny or admit the contents of the paragraph. So they're saying that table, they could not confirm or deny. And they are party to one case. They are party to one other case before the court. However, the allegations, and specifically allegations of malicious and defamatory statements, otherwise denied. And they essentially said, we deny it. You need to show proof. And it's essentially just we deny. You need to show proof. They admit that to the extent that certain statements have been posted on their social media pages, but they deny all other allegations, and they make them for the strictest proof. Okay, for that, negligence per se. All right, deceptive trade practices. So yeah, they did the answer eventually. So they said the plaintiff complaint fails to state the claim. Defendants have hereby incorporated fully statements are true and therefore not defamatory. Alternatively, defamatory statements are statements of opinion and not defamatory. They reserve the right to assert such additional information. So this was then a motion to compel. Then we've got the motion to compel. Because then we find out that there's been no oh, that's right. They also filed a motion to compel, and they also and opposed the protective order. Well, that's right. And there is a whole pile of stuff that's not on this file because they've kept it hidden. So here we go. Interrogatories. Identify all persons. Defendant's first set of interrogatories, and it's a request for production of documents seek. And this is where we're going to need this one for later. However, the defendant's discovery requests were tailored towards specific. Like, I don't know why, if you've ever been convicted of or pled guilty to a criminal offence, what's that got to do with it? That's right. They want balance sheets and stuff like that. Real estate matter isn't. We're going to keep this one open because I want to look at the other next one. Oh, yes, here we go. So then we've got a declaration here. Further you sayeth, declareth not, apparently. So we've got here to the plaintiffs, here's their interrogatories, all the stuff that they wanted. Which, remember, they didn't get many of them. Okay, then we've got defendant's request for production of documents. Then we've got, see, they want all the full financial accounting stuff. Court file, what's this one? Oh, yes, then they're showing envelope information, the e-service stuff, and we filed a motion. We will not be talking to you about it until this has been dealt with the court. Then we've got, which one is this one? Here we go. This is Mr. Martin. Why? This is where we find out that his relative had died or something, and it was sitting on the. He waited a week to assess the situation. He says that she responded heightened and agitated. She never once said she was expecting it. And then the father-in-law, who'd been in intensive care, passed away, and he. Imagine my surprise when I saw that the plaintiff had filed a motion for default judgment without even contacting me about the lack of receipt of an answer. Oh dear. And then it shows that. I will discuss settlement here. Here we go. Look. I will discuss settlement. Thanks, Graham. I'll discuss settlement with my client and see what they are open to. As stated in my previous email, unless we can stipulate a protective order, we'll be moving for one, and I plan on filing that motion. I'm not sure how much your client wants to spend on an answer. Here we go. Meet and confer. KJ. So he wrote, right? You have asserted that we agreed neither party would talk about the other publicly during the pendency of the case, but I've reviewed our email correspondence, and the only thing we agreed to do was not disclose online the contact information of the parties or their attorneys. Written agreement, the one I've just described, would you please send a copy so I can review it and advise my client? I don't think such a thing exists, though. I'm unsure of the continuing insistence that my client is violating. I appreciate the reach out about now and will discuss with them and my clients to get back to you. Hope you have a good afternoon. And then it's so there's talking about a settlement. Thanks, Graham. So it looks like Graham so then he said, she's from Graham, if your clients would like to discuss settlement instead at this juncture, I think that would be fruitful. I will discuss your request with my clients. Who's his clients? My client remains disinterested in product stipulations. We're already working on an answer. We'll have one filed next week. We're in so again, he's trying to do that. I'm just trying to find. Our office has been attempting to contact the court. Your client has a history of doxing people on the internet, displaying documents obtained during discovery process on her social media, and misconstruing the contents of documents she posts. This entire case is based on your client's egregious behavior. I would like to stipulate, I will retract my motions. If you would like to stipulate to the above, I will retract my motions and you can have discovery to you next week. We understand your client thinks some of the information we request is potentially sensitive. The information also directly relevant to your claims. I will not be sending discovery to your office absent of a ruling on our motion for protective order. I do not trust that the information sent to your office will remain in your possession, given your refusal to stipulate a simple agreement. And so then we have the documents spanning. I have not impunged your character or questioned your professional integrity, and I would appreciate if you do likewise. I'm under any number of professional obligations to not disgorge information. Oh dear, it's like a trip down memory lane, isn't it? Please find the answer we drafted. Oh yes, then it was his father-in-law in ICU, but it was somebody else. Yeah, so that was that one. Affidavit on the affidavit of defendant. She's a defendant in the matter. She's a celebrity news journalist. I am regularly cited and reported on national publications. I'm not the only reporter interested in here. So again, she's showing a simple Google search of 7M films. She yields 4 pages of results. So here she says she's a news journalist. I stand by my reporting. My stories are properly sourced using primary sources such as interviews, individuals, and court public records, secondary sources such as news articles in reliable publications. When I editorize, I believe my opinion is based on the fair reading of facts. As a journalist, I am accorded significant protection under the First Amendment of the United States Constitution. My reporting of the plaintiffs is unflattering but truthful. I do not have actual malice against the plaintiffs. I have no personal grudge against 7M, Robert Shin, Miranda Derrick, or James Derrick. As part of this litigation, I've agreed not to publish contact information for the plaintiffs. I have not published contact. I have not agreed to stop publishing stories about the plaintiffs. I have continued to publish well-sourced stories and fair opinion. So then she's putting in her Rolling Stone stuff, articles from Rolling Stones to prove her point, and other stuff here, and all the other people. But my question comes back to, did they use her as a source originally, or was she used as a source, or did the source use that? Okay, whether she put them on it is the question. All right, so then we've got that. And we've got another memorandum, lots of stuff. Defendant's memorandum in respect of missing the deadline. And they wanted the amended scheduling order done. At the same time, plaintiffs seek to punish defendants by the draconian measure of default judgment when they missed a technical deadline to file an answer. Then we've got a responsive motion. There's lots here. So the plaintiffs, the responsive motion to motion to compel. And we've got another memorandum. I'm sure I've seen something here about, once again, plaintiffs make careless errors of fact and law while most draconian measures. Reply memorandum supporting motion to compel. And it was Jennifer Moore. All right, then we've got another one. This is another Amber email stuff from Amber. I presume the same conversations with client. I note that they've changed the contents of their website to recharacterize what they do. I hope they are preserving any relevant evidence. All right. Oh, here we go. Selling souls. This was the doco. This was the doco that was supposed to have an active investigation. Oops. Selling souls. Here. Look. Look, 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 look. This is in Amber's stuff. She knew about the documentary. This is a multi-part that will document the investigate telemat. Okay. So this is an on-court file. However, this will not be a one-sided story. We'll give the church management, dancers, senior staff, and Robert himself the opportunity to share their side. Robert Shin's registered businesses and lawsuits. Our weapons. Here you go. Our weapons. Tim Milk. This is the doco. This is the doco. Melanie Lee, James Kim, Angela Derrick, B Dash's ex-wife, Katie Joy, Melanie the Wilkins, and Tim Milgram. And the team. Although this was a different team, wasn't it? And then showing that she shared it to social media. More of this, that she's sharing court documents. Again. So yes, it's very. Oh, sorry. I'm sorry. I've just realised. Oh, I've actually just realised that I've just let my chat go. I forgot. Oops. I'm sorry, guys. I've just been chatting away, paying no attention to chat. Hello, Ginger. Hello, people that have joined me. I'm sorry, Harrison. I know he tried to call me to tell me that oh, dear. Oh, I'm in trouble. I'll be in trouble tomorrow. I apologize. I know I'm still live. That's all right. I'm good. I'm glad I'm still live. I've just not paid any attention. I've just been rabbiting around here. Rabbiting on. Okay, so then we get this one. Oh, it's and I've got a million tabs here. So let's go for here. Yeah, this one. This was the motion, the order, the motion for default judgment denied, the motion for temporary injunction is denied, the amending schedule granted, and then there was the new schedule. The trial was going to be October. Defendant's motion to compel denied. Defendant's motion to compel discovery is denied as premature. Defendant's is granted in part, and then the judge went and talked about the protective order. And so then we get the protective order. Look, I'm just trying to show you I'm just trying to paint you the picture of where we are at the moment. But as you can see, Amber actually had information about the things. So the court adopts a protective order to a highly confidential, attorney as eyes only, all confidential and highly confidential. So the court and its staff, attorneys, persons shown on the face of the document who've authored it or received it, court reporters, the parties outside independent persons, and then it talks about the protective order. Essentially, it's still in place, okay? So then we've got, oh yeah, that's that one. I thought these downloaded in order, but they didn't. There's some more correspondence. There was substitution of counsel. Then we've got notion of motion to compel discovery. The responses, yeah, we did that. That was a court date. Okay, as I said, I'm more than happy. I'll put the link to the Google Drive here. Plaintiff's requests for first set. Oh yes, production of documents. So this is what 7M asked for. This is where I wanted to go. All right. So they wanted to know, produce any documents in your possession, custody, related to claims or defences alleged in the litigation. Produce any reference in your answers. Produce any and all social media posts you've made about 7M. Produce any social media you made regarding Robert Shin. Social media posts, yep. I want to get to, then they wanted correspondence to Derek's, and then they wanted tax documents because they want to see that. Produce any and all contracts you've entered into with third parties regarding 7M Films, Robert Shin, Miranda Derrick, James Derrick, and Shekinah Church. Produce any and all contracts you currently have with any production companies. Produce any and all correspondence regarding production of a HBO documentary. So at that stage, and produce any and all communications regarding the production of a Netflix documentary. So they asked for all of that. Then here are her answers, and this is what I want. This is really where I wanted to go, because Kathy, yeah, she objected to that. She doesn't know who she's calling. She's got no. She hadn't identified the media platforms, so she's listed her media platforms there. Instagram, Facebook. She's saying that she's got no employees. I want to get to the part where we get to the production companies. Oh, yeah. So then they've said, what information was provided to you supporting your statement that Miranda Derrick missed the family funeral? And she objected to that. And remember, she's got to do most of that. What information was provided to you? And this is what they're asking. All right. Now I want to look at the HBO. HBO stuff. Like they wanted to know, what information was provided to you to support your statement that he waterboarded? And she's using journalistic privilege. I can't see it here. I thought. So, yeah, so they've asked for the okay, so then we've got, what's this one? There's a few here. Okay, then we've got okay, so then they've asked for more. Then they followed up and said, well, we haven't got it yet. We haven't got our discovery yet. Plaintiffs requested all social media posts. Yeah. I want to see. Right, here we go. Request 21. So it says plaintiffs requested all communication regarding production of HBO documentary regarding plaintiffs. Defendants objected due to journalistic privilege. As previously outlined, defendants are not journalists. Further, the journalistic privilege only extends to journalists revealing their own sources, not to information an individual gave to a journalist. As defendants have given information to HBO or its affiliates for the purposes of creating a docuseries, it is assumed that contract has some type of monetary consideration to defendants. As defendants are potentially gaining monetary gain from this documentary, it goes to motive. Further, the conversations and correspondence given by defendants to the documentary are extremely relevant, as the plaintiffs are entitled to review the nexus of information between the defendants. We're told from their sources to what they stated on their social media platform as what information they gave. So they didn't do it. So, so request. So they did not, they objected to the request, which was produce any and all communication, and they cited journalistic privilege. So, it's very interesting. And then the interrogatories. So there wasn't a lot that came through. I'm looking for 23. So, I'm doing a marathon tonight, aren't I? Okay, so then we've got here sorting for the second motion to compel, because they were talking about here, because there was another motion, the Shekinah did motion to compel. So anyway, but I'm certain somewhere so they did extend discovery. They did discuss that they did eventually extend discovery for another 60 days. Okay, and then we've got another order. Then there was another matter to go in October. If you remember rightly, that was the matter to go in October. That was the motion to compel. And I think the default judgment from memory. Okay, and then don't forget that we've got, and they both essentially filed motions to compel. Then we've got more interrogatories that are outstanding. This was in October. And again, they wanted all the communications regarding the Netflix series. Okay, then we've got scheduling order. This is the new scheduling order. Okay. There was a judicial determination. Where was it? And then we had the motion to compel. So this is what I want to look at as well. So we get to the motions to compel. So we've got plaintiff's request of production, plaintiff's interrogatories 11. So 11. 11, 12, 14. So 11 is produce any and all correspondence to which the defendants discuss 7M films. 12, any correspondence, hi mum, okay, in which they discuss Robert Shin. Any they for 14, yeah, and then it says 15, 16, 17, 18, 19, 20, and 8, 19, 21, 40, 41, and requests for production 11, 12, 13, and 16. So then we go back to here. Oh. Hold on, here. So a lot of these were done. So 17 was 17 there? Yes, 17, her tax records. 18, without a crystal ball's tax records. Produce any and all contracts you've entered into with third parties. 41. Oh, that's outstanding production. This is stuff they're still looking for. Okay. Oops. Okay, so so they objected to that. Then we've got so produce that, and then we've got request for production. Oh, yes. Plaintiff's request for production 19, 20, 21, 23, 24. That is the information regarding the production of documents. Here. So she is compelled to produce all and any communications regarding the production of a Netflix documentary, all contracts regarding the production of the next, any contracts, communication with Netflix, any communication and contracts with HBO. That has come out in here. Now, defendants' interrogatories. What did she ask for? So, yeah, just waking up. Oh, yeah, I've been online for nearly 2.5 hours trying to work out. I swear I saw somewhere that she talked about the docuseries, but we know that in Amber's stuff that there is a docuseries. She had documentation for docuseries. So I'm just trying to find out, just going through all the court stuff at the moment to see what I can find. Because I am certain I read somewhere or I saw something about the fact that she said that she wasn't in the docuseries, or she wasn't the source for it or something. That's all. It's just. But yes, so in the motion to compel, she actually has to provide the requests are discoverable as they relate to defendants' motives, potentially gaining financially. I think so, Will. Yeah. I mean, what we saw in the HBO thing is that she's one of the sources. It says these requests are discoverable. Defendants they offer no legal support for their claim that the production companies would be required to make an independent argument regarding of any of the contracts they entered into with the defendants, and the court does not find this argument persuasive. So she has to submit that to the court. That's discoverable. So Well, that's the thing. And I mean, her little victory dances that she's done today may come back and bite her because, she's sort of jumping up and down. But yeah, so she's got to submit, and that was all due by the 19th of April. By the court order that we saw. Let me go back and pull that up again. Deadline for discovery, 19th of April. So that should have already been there. I'm sure there's going to be emergency filings. I have no doubt. I reckon that there has to be more coming. I mean, there has to be. I would not be. I mean, look, I would not be surprised if 7M is going to say, "Look, you've declined a protective order before. Are we at that stage now where we have to get it?" Or now is 7M going to go to the court and ask to add Netflix to amend the complaint to put in Netflix, all the producers of the docuseries? But the issue that we've got is if she does. See, this is what she's been promoting. She's saying she's been working on it. Now, if she's not submitted to the court, that if she can't now say to the court, "Oh, I wasn't a part of it," because she's blasted all over her social media. Again, this that I have been working on with an amazing and talented, empathetic team. Well, Ginger, there's two things I can think of. Remember, I'm not a lawyer. They could actually file an injunction to stop the Netflix documentary from going to air. They could depose all of the producers and they could depose to find out what the information. So there's a few things that you could do. So again, and then she says, like, "I'm so proud to play a small part." She says that she was a consultant in it. So again, we've got contract obligation, and then we actually get to the point of malice. We get to the point of malice. We get to the point of actual malice, because she says, "So proud to play a part of this, bringing this production as a consultant for the archives of records that had to be sifted through to accurately tell the stories." If she was working for this, and then someone says, "I boycott this whole project and do not support anything," I don't know who Lorna Reinhardt is, but people are starting to jump ship now that they found out that she's bragging about it. I mean, it could get pulled from that. It could get pulled from Netflix, for all we know. But anyway, I'm. Do I think that there could be some underhand dealings being dealt with? She haven't had spite. No, that's right. Because she cannot. She was so excited. She's And don't forget, she says that she was part of it, but she had no idea when it was released. Either, don't forget. It was all for financial gain. So it comes down whether malice for whether financial gain can be deemed as malice. It will come down to that. I mean, there are bits and pieces around that argue both ways. But with Balls went and found all the said the exposing 7M actually said it first about it, and then she did some searching for it. But I would be really surprised though that Netflix lawyers wouldn't have cast some warnings about it because of the. I think it's a bit. I don't like it because of the fact there's active litigation going on with some of the parties, some of their people that they've talked to. Documentary in a group of prominent TikTok dancers trapped in a cult masquerading as a management company called 7M. Now, here's the thing. What happens on the balance of probability? The judge finds that Katie Joy did defame 7M for alleging that they were a cult. On the balance, remember, you only need in civil cases, you only need to find out on the balance of probability. Doesn't need to be beyond reasonable doubt. So if it is just deemed that on the balance of that she has made it all up, then where does that leave the docuseries? And that's why I'm saying I just find it a bit bizarre. That's all. Anyway, I need to go to bed. It's I've been online for nearly my longest ever. Thank you for helping me with that because I knew that I'd seen some documentary stuff there, but I thought if you have anything that shows where she's referred to the documentary or she's not part of it, because I know that she said on live stream she doesn't get involved in documentaries and stuff because she, people always steal her work. So I find it very bizarre for that. I can't either, Ginger. I really can't either. So, but just to recap, her deadline for discovery was the 19th of April. Depositions shall be concluded by July 26, 2024. So, as I said, if I was them, I'd be deposing all of the Netflix people to find out what they gave her. That's what I would do. Then they've got to go to alternate dispute resolution and deadline any other motions that need to be done. Because and there still might be. Yeah, it's just for, in my opinion, it's just a great big mess at the moment that she's got herself into, and she just cannot keep her mouth shut. And if only she'd keep her mouth shut. I just don't know. And again, wait on. Oops, I've just got to. I need to show you these. Oops. Just before we go, let me share her stories with you because my mouse is dying by the looks of it, so I apologize. I'll have to go back again. All right. Just want to pause these. All right. So this is where she's saying she's worked on the docuseries. Okay. This series will not have happened without Vilma Vandermeer's WV Entertainment Production Company, Dirty Robert, Jessica. Yes, it was. And Derek Doreen's Blood, Sweat and Tears. It looks like it's the HBO docu, the one that we saw in the court documents. And then we've got, she had to do a Sister Wives video. Apparently unseen footage. What on earth is she doing with those sparkles? And then Miranda Wilkins' family will share their story in the series. A group of prominent TikTok dancers are trapped in a cult. Among them is Miranda Wilkins, whose family is desperately trying to get their daughter out. Isn't she Miranda Derrick? As a result, as other dancers have escaped the world to rebuild their lives until they... So that's the synopsis. So anyway, all right. So thank you for sharing. Thank you if you've made it on the replay crew. If you're going to look, if you want to look at the documentary stuff, it's about 2 hours, 2:03:21. You'll see the synopsis and all the players in the documentary that was submitted by 7M that they got hold of, that they had heard that she was going to be involved in. So the 2 hour 02:03:21. I'll put that timestamp here. If you go to that timestamp, that's where the docu-series is mentioned. Okay, that's the timestamp. I hope you have a good one. Thank you for joining me. It was a very long night, and Harrison, he wants to come on the live stream, so I have to put him on the live stream probably tomorrow. All right, bye for now.